215. The Privatization of Morality and Social Decay. Chalcedon Position Paper number 60, March 1985. One of the errors of the rationalistic temper in our times and earlier has been its depreciation of both religion and history. The assumption too often has been, as with Hegel, that the rational is the real. That is, what a man who sees himself as rational conceives to be reasonable has at least a logical inevitability, if not an historical reality. To confuse the ideal with the real leads to the brutalities of modern revolutionary history, as men force their rational, quote, realities, end quote, onto masses of men. A rationalistic approach is non-historical. Thus, early Protestants catalogued instances of Catholic persecutions to give a picture of Catholicism which did no justice to history, and Catholics wrote similar works on Protestants. Such approaches have little historical value. They express a bias, not an understanding. To understand the First Amendment, we must ask why it is a product of Christendom and not of some other religion and its culture. Greco-Roman cultures did not allow the freedoms we take for granted. In antiquity, either the state, the ruler, or the office was seen as divine, as God walking on earth a la Hegel. Rome, for example, was the most, quote, liberal, end quote, of ancient orders. But Rome saw religion as a necessary social cement, and hence to be strictly controlled and regulated. All religions had to be licensed and governed by the state, and the conflict with Christianity was over this issue: the refusal of the Church to submit to control. This refusal was born of Old Testament faith. God's realm is to be beyond man's control. The great victory of this faith against an alien power is set forth in Ezra chapter 7, the agreement of the Persian monarchy to refrain from taxing, regulating, or controlling the Temple of Jerusalem and the practitioners of its religion, even to the porters and doorkeepers of the temple. Later, Rome gave to Judea substantially the same immunity, although controlling the elections of high priests. The Church inherited this immunity until the Jewish-Roman War of AD 66 to 70, and fought for the totality of it thereafter. During much of medieval history, despite the problems of dealing with newly converted barbarians, this freedom existed to a degree, but the states of Europe and the Holy Roman Empire sought to re-establish the pattern of control. We miss the meaning of medieval religion if we fail to see it as a long history of struggle, with the states in the main controlling and using the Church. The statist pattern from pagan antiquity through the centuries and well into the Christian era has been religious toleration. In religious toleration, the state prescribes certain faiths and establishes and regulates others. This was the goal of medieval and modern states. In legal toleration, the state determines which groups will be tolerated. Toleration is also the premise of the U.S. Internal Revenue Service, the federal government, and most states. Tolerance and establishment go together, because the act of defining the limits of toleration is the establishment of licit religion. As against this, the American pattern represented a major break with past civil standards and a return to biblical requirements. Two things in particular marked the constitutional settlement. First, the word sovereignty was completely avoided. It was held then and later that sovereignty is an attribute of God alone. Second, the United States broke with the toleration establishment pattern to place itself entirely outside the field of religion. Religion was recognized to be an independent sphere from the state, and neither church nor state are to have jurisdiction over one another in federal policy. The First Amendment thus set forth religious freedom, not toleration. At the same time, however, Enlightenment thought held that religion and morality could be separated, and that non-religious grounds could be found for moral law. By this, they really meant non-theistic grounds, that is, rationalistic and humanistic grounds. They were thus separating theistic religion from morality, not humanistic religion. George Washington spoke against this opinion in his farewell address, saying, "And let us with caution indulge the supposition that morality can be maintained without religion. Whatever may be conceded to the influence of refined education on minds of peculiar structure, reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle. No human freedom is or can be absolute, and the same is true of religious freedom." This fact came into focus in the case of United States versus Reynolds, 98 United States Reports 145, wherein the U.S. Supreme Court said, in part, concerning the Mormon practice of polygamy in relation to the First Amendment, "Congress was deprived of all legislative power over mere opinion, but was left free to reach actions which were in violation of social duties or subversive of good order. There never has been a time in any state in the Union when polygamy was not an offence against society, cognizable by the civil courts and punishable. It is impossible to believe that the constitutional guarantee of religious freedom was intended to prohibit legislation in respect to this most important element in social life, marriage. While, from its nature, this sacred obligation is, nevertheless, in most civilizations, a civil contract, and usually regulated by law. Laws are made for the government of actions, and while they cannot interfere with mere religious belief, they may with practices. Suppose one religiously believed that human sacrifices were a necessary part of religious worship. Would it be seriously contended that the civil government could not interfere to prevent sacrifices? Can a man excuse his practices because of his religious belief? To permit this would be to make the doctrines of religion superior to the law of the land, and, in effect, would be to permit every citizen to become a law unto himself. Government could exist only in name. It matters not that his belief was a part of his religion, it was still a belief, and a belief only. This decision recognized clearly the nature and dimensions of the problem. No civil government can exist where there is a total freedom of religion. Among the practices found in some religions are ritual prostitution, murder, human sacrifice, cannibalism, incest, bestiality, and much, much more. All these and other practices have at one time or another been established by some civil order, great or small. To grant total religious liberty is to deny the possibility of civil government. On the other hand, in United States versus Reynolds, the Supreme Court avoided the problem George Washington had called attention to, the false separation of religion and morality. The court called monogamous marriage the sacred obligation. But this was Reynolds' contention, that polygamy was, for him, a sacred obligation. On what ground could the court limit the sacredness to monogamy? The answer is an obvious one. The court presupposed the validity of Christian morality and saw it as alone having a licit status. Washington had called attention to an ancient bit of knowledge and wisdom which the 18th century had called into question, namely, that all law represents a moral order, and every concept of moral order is a matter of religious faith and expression. Laws prescribe certain kinds of actions to protect thereby other and licit behaviour. Every law, whether it is civil, criminal, or procedural, represents a vision of moral order which the lawmakers and courts seek to approximate and attain. That vision of legal moral order is a religious vision. Every legal system is thus an establishment of religion, inescapably so. This does not mean the establishment of a church, but of a religion, a very different thing. Such an establishment does not approve of a particular form of theology, but simply of the religion in question as the moral foundation of the state. It was this that Justice Joseph Story had in mind when he spoke of Christianity as the foundation of our legal and social order. He held Christianity to be a part of the common law. The sociologist Eugen Rosenstock-Huessy saw the common law itself as a Christian product. In 1955, John C.H. Wu, in Fountain of Justice, commented on this question thus: "The question has often been asked if Christianity is a part of the common law. It depends on what you mean by Christianity. If you mean a revealed religion, a faith as defined by the Apostles' Creed, it is not a part of the common law in the sense that you are legally bound to believe in it. Christianity as a faith comes into the courts, not as a law, but as a fact to be taken judicial notice of, on a par with other facts of common knowledge. On the other hand, if you mean by Christianity the fundamental moral precepts embodied in its teachings, it is a part of the common law in the same sense that all the universal principles of justice written in the heart of every man are a part thereof. In this sense, there is a common concern in both church and state." The political scientist James McClellan, in Joseph Story and the American Constitution, 1971, held, "At bottom, church and state are forever united. Their total separation impossible." Page 126. Church and state are not united in any institutional or legal sense, but in a common concern on common moral premises for a particular form of moral order. The freedom recognized by the First Amendment serves to enable both church and state to work with greater independence and vigour for that moral order. Basic to that freedom is the belief that sovereignty does not reside in the human sphere, but in God alone. It follows, therefore, that no human agency, such as church or state, can claim exclusive or total jurisdiction. Totalitarianism is a consequence of non-theistic doctrines of sovereignty. If God alone is Lord or sovereign, God alone has total jurisdiction over all things. The absence of a doctrine of sovereignty in the Constitution made the First Amendment possible. The rise of the doctrine of federal sovereignty is now threatening the First Amendment. Only a true doctrine of lordship or sovereignty can turn the present drift into totalitarianism around. Only then can we counteract what Judge Robert H. Bork in Tradition and Morality in Constitutional Law, 1984, called constitutional nihilism. We must remember, however, that constitutional nihilism has its roots in moral nihilism. Gertrude Himmelfarb, in the February 1985 Commentary, Volume 79, Number 2, writes on, "From Clapham to Bloomsbury, a genealogy of morals." The Bloomsbury Circle, which included the economist Keynes, Virginia Woolf, Lytton Strachey and others, derived its premises from the philosophy of G.E. Moore. Moore not only separated religion and morality, but implicitly made both unnecessary, so that, as some of his followers soon saw, the problems of society were simply technical and managerial ones. The Bloomsbury Group thus viewed their lifestyle in terms of aesthetics, not morality, and they called their, quote, liberated, end quote, homosexuality, quote, the higher sodomy, end quote. For them, morality was not a problem because it was irrelevant. The influence of this circle is quite pervasive in our time. It affects our media, our legislative assemblies, and our courts. It turns the meaning of the First Amendment upside down. That document, instead of setting forth the independent sphere of religion so that it might better govern and inform public faith and morality, is now seen too often as a guarantee for every kind of immoralism and social disorder. The First Amendment was written to give freedom to the expression of religious and moral convictions in the civil sphere in terms of an historic faith that biblical religion constitutes an independent sphere. It has now become the prop of a philosophy which insists on the irrelevance of religion and morality to social order. The consequence of this religious and moral nihilism is constitutional nihilism. Judge Bork wrote also of the current privatization of morality, which requires the law of the community to practice moral relativism. It is this that leads to constitutional nihilism. Behind all this lies a moral nihilism. As a result of an emphasis on appearance which was strong in the Victorian era, people are now judged socially and aesthetically, not morally. A man may be a homosexual, a dedicated adulterer, a dishonest dealer, or more. But unless there is a public scandal connected with him, he is acceptable if well-dressed, well-bathed, and aesthetically right in his lifestyle, whereas a virtuous man is looked down on. This is the Bloomsbury tradition, although its roots go deeper. Until men recognize that law, morality, and religion are inseparable, and religion is basic to social order, our decay will continue. The privatization of morality is anti-biblical, and it leads to moral and social nihilism and death.